Hey everyone, welcome back to the channel. Today we've got a sovereign citizen of the Moorish variety facing off in a Texas courtroom. The judge presiding over the case is Christopher Morales, who previously shot down a dismissal motion filed by the state's attorney. Now we're here for a hearing where the defendant is pushing for reconsideration on that denied motion. So let's jump right in.
We're on the record 21 CCR 221014 and 21 CCR 221009, State of Texas versus Antoine Jermaine Davis Bay. Mr. Bay, this is your motion to reconsider. I've reviewed your motion to reconsider. I've reviewed the response and then your reply to the response as well. I'm going to permit 10 minutes per side for argument, and then I'll make a ruling at that time. So, Mr. Bay, you may proceed with any argument you'd like to make.
Okay. So this situation stemmed from an arrest from March 8, 2021, from a lawful arrest without a warrant. Sorry about that. Okay. This is a situation between hypothetical suspicion versus a concrete crime. Whereas in this situation, no concrete crime had took place prior to the unlawful traffic stop. Okay, the state has failed to even establish a probable cause for a warrantless arrest and search, and they had no justifiable basis exist to continue prosecuting this case. The charges of this case do not meet the requirements of actual concrete criminal activity as defined under Texas law and federal law. For one, the absence of a sworn affidavit of probable cause by the arresting officer further renders this arrest unlawful. An injured party or a complaint with a legally recognized injury.
Hey, Mr. Bay, my court reporter is having a difficult time understanding. If you would face the camera, that way your voice could be heard clearly. Thank you, sir.
Okay. Can you hear me clearly now?
Yes.
Okay.
Just maybe slow down just a hair on your speech. Thank you, sir.
Okay, no problem. Okay, well, I'll just repeat what I said. So this situation happened from an unlawful traffic stop without a warrant or a concrete injury from an injured party prior to the traffic stop. I want to make a note also that the traffic stop and the other offense of possession of marijuana was dismissed back in 2021, approximately around the time when the case was first initiated. I did upload and file on record evidence of that notice of rejection.
What he's arguing here is that since the possession of marijuana charge was dismissed, all evidence gathered against him should be thrown out too. But he's mistaken. Just because one charge is dropped doesn't mean the entire traffic stop becomes unlawful. The stop itself can still be valid regardless of the dismissal.
So I want to point out the fact that this is a case of hypothetical suspicion versus a concrete crime. Okay, the mere act of a traffic stop does not constitute probable cause for broader detention or search as recognized by Terry versus Ohio. Okay, hypothetical suspicion does not equate to criminal behavior. Okay, and Texas arrest or search without evidence of a crime of probable cause contravenes Texas Code Criminal Procedure Article 14.01. Section B, which requires that an offense be committed in an officer's presence or viewed to justify a warrantless arrest. The officer, Jazz Roberts, who was the arresting officer at that time, he did not have any probable cause or reasonable suspicion to even initiate the stop. And then once the stop was initiated, he didn't have any authority to continue with a search or an arrest, especially not just based off of mere traffic citation. Like I noted, that traffic citation was dismissed, okay, indicating that they didn't have any probable cause to prosecute a traffic citation against me. And also, the adjoining case that was with it was a possession of marijuana, which was dismissed um, um, prior to even we having these hearings.
I've already mentioned that dismissing the initial charge doesn't automatically make the traffic stop unconstitutional. However, if a court ruled that the stop was unconstitutional from the start, then any evidence obtained would be inadmissible. In that case, you'd actually have an argument to stand on.
Failure to uphold due process requirements. Okay, due process under the 5th and 14th Amendment requires fair treatment through the normal judicial system. Due process clause protects against arbitrary government actions, including unlawful detention and seizure without legitimate legal basis. In Texas, due process violations occur when the rights to fair and impartial hearings are denied as well. And this is on the Texas Constitution, Article 1, Section 19. Okay. Also, the officer, as I mentioned, failed to sign an affidavit of probable cause, which is required under Texas Code of Criminal Procedure, Article 1505, subsection 2, which mandates that a written statement establishing sufficient factual grounds for arrest be presented and signed by the arresting law enforcement officer, which I requested a police report from Rosenberg Police Department, which is the arresting agency. I uploaded the results of what I received of that, which is pretty much a blank report. And it failed to have any attached affidavit of probable cause with it. Also, the prosecutor in the last hearing presented me with a discovery, which also failed to present any affidavit of probable cause. Okay. Okay. Also, unlawful search and seizure falls under Texas Criminal Procedure Article 38.23. Okay. The prosecutor alleged the odor of marijuana. The odor of marijuana alone, without physical evidence of probable cause of actual crime, is insufficient to justify a vehicle search. Once again, was no testimony or affidavit of probable cause to.
Honor, if I may, I'm going to object to this. This is outside the scope of the hearing.
Sustained. Let's stay within the scope of your motion.
Well, this was all inside my motion as exhibits and as a brief.
Allegations made by the state were not contained in the defendant's motion.
Agreed. Sustained. Move on.
The answer is a big fat no. They won't be dismissing your evading arrest charges or any others just because you have a third-grade level understanding of the law and a major misconception about what makes a traffic stop unlawful. Your charges will stand regardless.
Also, the fruit from the poisonous tree doctrine applies to this case. All evidence obtained as a result of a warrantless arrest and search must be suppressed, case dismissed under the fruit of poisonous tree doctrine. And that's Wong Sun versus United States, followed by citation. This doctrine.
Yeah. Mr. Bay, can you spell that name for my court reporter, please?
Yes, ma'am. Yes, sir. Wong Sun is W-O-N-G, first name, last name Sun, S-U-N. That's versus United States.
Thank you.
You can continue now. Thank you.
Okay. This doctrine bars evidence obtained from unconstitutional actions, including unlawful stop searches and arrests like probable cause. So for these reasons, I request that the court grant this motion for reconsideration to the motion to dismiss for lack of subject matter jurisdiction based on the due process violations, lack of probable cause, and other evidence that's lacking as well. Warrantless arrest, like as I mentioned in my motion and also in my brief. Okay, and I also request that if this motion is not granted, that I could get a full and complete police report to prepare for a defense. Also, evidence supporting the traffic stop and alleged crime that gave rise to these charges that I'm facing with the evasion of arrest and charges of unlawful possession of a firearm. Because for it to be an evasion of arrest, it has to be grounds for an arrest for me to invade. There's no evidence of this. So with the incompleteness of discovery by the state and the failed documentation that the prosecutor failed to provide with a record of events that would normally be captured in a police report, I am prejudiced from preparing a defense, and I'm deprived of crucial information necessary to challenge the validity of the stop and subsequent search. So I do compel that full discovery, and I do request that this matter be dismissed.
The prosecutor ironically cites exactly what you say they don't. You'd think that hat would at least protect one working brain cell, but nope. It just highlights how foolish he looks for no reason. Honestly, that's pretty based.
10 minutes. State, quick question before you respond. Has Mr. Bay had access to discovery in this case? He was admonished for self-representation already. Can you provide how long has he had access to discovery? Does he have access to everything in your file? Please.
Yes, Your Honor. That was actually the first point I was going to make in my response. Mr. Bay, can you confirm the email address that you provided on the docket control order that was signed on July 23rd, 2024?
It was.
Will you
Okay.
spell that, sir?
Last bayby@gmail.com.
And Mr. Bay, is that the same email address that we have received responses from you on October 23rd, November 6th, and November 13th?
Yes, it was.
That is the same email address the state sent you discovery, which would include the PC affidavit that was signed by the arresting officer, as well as the complete offense report that you just told the judge that you did not have access to. That information was shared with you to that email that you just confirmed on October 19th.
I never received any email with a police report, and I requested the police report over 2 years ago.
Did
So
you
the
request it? Who did you request it from?
the Rosenberg Police Department.
Okay. Please send me, I will do my best, but please send me an email immediately following this hearing so that I can provide you a PDF of that document so that we're not going through our portal.
Okay, no problem.
Now, in response to some of these statements or allegations made by defense, again, as I just made clear, the defense has had access to the discovery since at the very least October 19th, 2024. I can't speak to whether the previous prosecutor had shared any of the discovery. I know he was admonished, I believe, on the same date that the docket control order was signed. So we haven't been able to go through actual defense counsel for this, Judge. Again, I will send over in an alternative format the PC affidavit and the offense report so that the defense has access to a complete set of information. On the last setting, I believe it was November 7th, defense was provided copies of all the media, Your Honor. So he does have access, at least from my understanding, to all the discovery. Now, as to points made in his motion, first and foremost, Mr. Bay has not been charged by information with evading arrest. Mr. Bay has been charged with fleeing a police officer as well as a unlawful carrying of a weapon. Now, to his first point of hypothetical suspicion, I do not know where the defendant finds that within the case law. I have not found anything of hypothetical suspicion. What justifies a traffic stop in this particular case is reasonable suspicion. As seen in the PC affidavit, as well as the offense report, the officer had a on-view offense for a traffic citation, which was speeding. The officer attempted to conduct a traffic stop for said speeding, at which time the defendant failed to pull over as required by Texas law. That in and of itself constituted fleeing a police officer, which is in violation of the Texas Transportation Code. I believe it is section 545.421. At the time of the stop, the officers attempted to make contact with the defendant. They observed an odor of marijuana. There is case law stating an odor of marijuana alone is enough to support probable cause to conduct a warrantless search of the vehicle, which is precisely what was done here.
I object, Your Honor.
Give me your legal objection.
The prosecutor has failed to mention any case law support his allegation with his brief or anything.
The case law in support of that was in the response to your motion, defense.
Yeah, it was, Mr. Bay.
Can you please
Case law makes it clear the odor of marijuana can justify a warrantless search of a vehicle under the automobile exception of the Fourth Amendment. And he goes on to cite Stringer v. State, Rocha v. State, Isaac v. State, and then he even cites additional case law, Cameron v. State. So it is cited and they're overruled.
A probable cause search was conducted on the vehicle. Again, this is as alleged by the state, at which point in time, the weapon was discovered within the vehicle as well as the contraband itself. I do not know, again, going to one of the points defense made, I don't know what due process rights are being violated here, which would warrant either suppression or a dismissal as defense has requested. He's claiming that he has not had the right to a fair hearing. PC was found by the magistrate at the time defense or the defendant bonded out. The state has provided copies of that bond paperwork, which was also sent to the defense at the time all discovery was shared. Again, I will re-provide that to the defendant in an alternative way. PC was found by the magistrate. So he's claiming he has not had he hasn't had a fair hearing, but the magistrate found PC at the PC hearing at the time that he bonded out. So I'm not quite sure what fair hearing he's alleging he has not had a right to. I know he also made reference to not being able to confront witnesses against him in his motion. We have not had a trial yet. No witnesses have been presented for cross-examination. I will say, and obviously I will provide this to the defense electronically, Your Honor. I wanted to, at the very least, bring this to the court's attention. I have two cases. First is Born, B-O-R-N-E v. State. Citation is 593 Southwest 3rd 404. I have a copy of it for the court. May I approach?
You may. Did you get that citation, Mr. Bay?
Yes.
Similarly, I also have Lewis v. State. Citation is 532 Southwest 3rd 423. In Born v. State, the court makes it clear that arguments such as those the defense is making are sovereign citizen style arguments, which have roundly been rejected by all the courts, all sister courts. In Lewis v. State, they make a similar point. And in that particular point, or in that particular case, rather, the judge appointed standby counsel for the defendant. The state wanted to at least put this on the court's radar in that there are certain concerns the state has based upon the filings made by the defendant, and that one of two things is either occurring.